Good evening, everyone. Thanks for joining us for this session where we plan to discuss about the recent judgment of the Supreme Court under the Provident Fund Act. To start with, the large question as employers have is, does this judgment have any impact on employers? It's a big no. There's going to be no additional financial impact on employers, this judgment. So whatever has already been contributed, there's going to be no further contribution. This is more about pension and how employees' pension could be more and how the Provident Fund organization would be liable to pay a higher pension to its members. So to start with, to whom will the judgment be of benefit? For those members who have been in the Provident Fund scheme prior to 1/9/2014 primarily, and those whose salary was in excess of the wage ceiling. So either it be 6,500 before 1/9/14 or 15,000 thereafter. And those who have been contributing on their entire basic wages over and above the ceiling. So before September 14, the ceiling was 6,500, but let's assume your salary was 10,000 or 20,000 or 30,000. And on the entire amount, Provident Fund contribution was made by your employer, not your contribution, but if the employer had been making contribution over and above the ceiling limit, then there would be certain benefits flowing from this judgment. The basis of this judgment is the pension scheme. Section 6, capital A of the EPF Act empowered the central government to frame a scheme for pension. And accordingly, a scheme was also framed by the government way back in 95. In terms of this, what happens is your employer contributes 12% of your basic wages, and of that 12%, 8.33 so the goes to the pension, and 1.16 of this is contributed by the central government. This is how the scheme is. Just an illustration as to how it happens. So if somebody's basic salary was 40,000 rupees, the employer's contribution is 4,800, the employee's contribution is 4,800. Now we need to look only at the employer side. This is nothing to do with the employee side. The employee contribution goes to Provident Fund. Out of the employer contribution of 4,800, we can split it because the ceiling, let's assume, is 15,000 rupees. Then on that, only 1,800 actually the employer needs to contribute, which is on 15,000 rupees ceiling. 12% comes to 1,800. So that is called the mandatory contribution. But the employer over and above that also contributes, which is voluntary. So if you look at it, that is 3,000 rupees, or that is 12% on 25,000 rupees comes to that. So that's how the mandatory and voluntary contribution. By default, even if the employee doesn't do anything, this mandatory contribution of 1,800 of this 1,250 rupees goes to the pension scheme. This is already settled prior to September 14 or even today from 95 onwards. So if you're contributing over 15,000 or whatever it is on the ceiling limit, so ceiling of 15,000, on the ceiling limit of 15,000, contribution would go to the pension scheme. So that is 1,250 rupees would have gone. The remaining amount goes to 550. So if you don't make any change, what happens then is, out of the voluntary contribution of 3,000 rupees, the entire 3,000 rupees goes towards pension, Provident Fund. There's no contribution to pension at all. So the entire amount goes to Provident Fund. And the pensionable salary, so for purposes of computing pension, the pensionable salary will be 15,000 rupees only. So on 15,000 rupees alone, you will get your pension. There is also a provision under the pension scheme to contribute more. How does it arise? That is what we are now looking at in this second screen. So if the employee can opt, saying, out of the voluntary contribution, also I want contribution to go to the pension. So the same example of 40,000, there are 4,800 goes towards employer, and in that mandatory contribution of 1,800, 1,250 is gone. Now what we are worried about is only the right hand side in the voluntary contribution towards pension. This 2,083 rupees can go towards the pension provided the employee gives an option. So employee should give a written option to the EPFO saying, I want out of this voluntary contribution made by my employer, I want 8.33 of this also to go to pension. This is the first round of litigations which ended up in the judgment of R.C. Gupta. In R.C. Gupta, the Supreme Court said this option by the employee can be done at any point of time. The employer has paid 4,800 to PF. It is only a bifurcation of that amount. Of that 4,800, how much goes to pension, how much goes to PF is getting bifurcated. The entire amount was with the Provident Fund organization. Therefore, employee can opt saying, I want a larger portion to go to pension at any point of time. And there is no limitation for the employee to make this option. This is what R.C. Gupta said, and it also said that the employees who have already retired and taken the money, they can repay the money for a higher pension. And why do you need that? Because when you contribute on 40,000, on the higher contribution, your pensionable salary is reckoned as 40,000, and that based on that, pension is calculated. So this is the position that prevailed pursuant to R.C. Gupta. Of course, R.C. Gupta came about much later. Going back slightly back, we're now going back to 2014. The central government brought an amendment, one to the PF scheme. First to the PF scheme, where it increased the salary ceiling from 6,500 to 15,000. That was under the PF scheme. Next is under the pension scheme. Under the pension scheme, it brought about a few changes. First is, before the amendment, what they used to do is they used to take only the average of the last 12 months as pensionable salary, and based on that, pension used to be taken. But then they amended it to say, I will take the last 60 months average. So what happens when you go back by 60 months, the average comes down, so the pensionable salary comes down. So even if your pensionable salary, let's assume on the date of your retirement was 40,000, but 5 years back you would have got only 30,000. When you average it out, it could come to around 36, 37,000 would be your pensionable salary, even though at the time of retirement you would have got around 40,000 rupees as salary. It goes back to 60 months average, therefore your actual salary could come down. So that is one amendment that happened. Second is, of course, the ceiling of 6,500 was increased to 15,000. So the default, by default, the maximum pensionable salary increases to 15,000. So even if an employee doesn't opt to 15,000, it will be reckoned for pension automatically. The third is, they also said, if somebody joins the scheme new, and if their salary is going to be more than 15,000 even at the time of joining, that is a voluntary person voluntarily joining for PF scheme, such persons cannot become members of the pension scheme. And the last one is, which has two elements to it, is if your salary, as of 1914, let's assume your salary was 25,000. And even prior to the 1914, you were paying on 30,000 or 25,000 on the higher basic actual wages, you were paying contribution. even such persons should give one more option within 6 months saying, I want to continue on a higher pension. And in such cases, they said the 1.16% that government normally contributes will not be contributed by the government. Government will contribute only up to 15,000 rupees and not beyond the 15,000 rupees. That will be taken up from the employee's PF. So these are the changes that came about. All these changes to the pension scheme were challenged before various high courts. High courts held in favor of employees, and the issue went to Supreme Court. As I already said, there was a judgment of R.C. Gupta, and the R.C. Gupta also, the EPFO wanted a review because it said that there is no time limit for switching over. So now when we go back, these are the issues that were there. So when you're taking 60 months preceding date of exit instead of 12 months, is it correct? This is one of the issues. Second, fixing 15,000 rather than the actual contribution. Is that permissible? Third, one more option within 6 months. So I am already contributing on a higher ceiling. Now directing me to give you one more option. Is it within 6 months I should opt once again? Is this right? Then the additional payment, additional contribution of members to the extent of 1.16%. Is this correct? And also the cutoff date to avail, basically go back to that 6 month period and things, because R.C. Gupta is already there. Now, as I said, high courts have already held that all these changes are bad in law for different reasons. Kerala High Court gave a reason of the economic aspects, saying today 15,000 is no big amount, and with such small pensions, people can't be there, and kind of went into the economic aspects more than the law. Rajasthan High Court had its own reasons. So all these landed up and batched up in the Supreme Court. So what is it that the Provident Fund organization argued was the option to contribute more than the salary limit. It's on voluntary basis. It is an option that the employees do. And in such cases, there is no vested legal right for the employees. And therefore, the amendments are all in order. And the salary fluctuations, what they argued is some employees on purpose, their salaries are increased in the last 12 months. And a higher contribution is paid on the last 12 months alone. And therefore, the pension that is payable becomes higher. And therefore, we have made it 60 months average and not 12 months average. And these are various arguments that were made. The Supreme Court has accepted most of the arguments. The first of the argument that was accepted was that this changes to the pension scheme, GSR 609, the main communication by which that was upheld as legal and valid. Second, however, GSR 609 sought to differentiate between exempted and non-exempted establishments. So under Section 17 of the Provident Fund Act, you can seek exemption. So they said exempted trust employees cannot ask for a higher pension, can only contribute on 15,000 to pension, not on their actual basic. That has been struck down. So they have said you cannot distinguish between an exempted and a regular establishment. Both are under the same pension scheme. That differentiation is bad. So even exempted employees can make an option for a higher pension. Then it has gone on to say those who have till date not given an option can given an option for a higher pension. So if you want to contribute or already you've been contributing, you want part of it to go to pension, you can beyond the ceiling limit, then within 4 months, such employees should give an option. Supreme Court has upheld the R.C. Gupta earlier judgment and has directed implementation of the judgment within 8 weeks. And it has struck down the law which mandated that 1.16% of the government contribution in excess of 15,000. That is, when you contribute over 15, up to 15,000, 8.33 goes to PF from the employer's share, and 1.16 government puts it into the pension equal amount. Above 15,000, they said 8.33 will be taken above 15,000 from the employer share, but the 1.16 will be taken from employee's contribution. Government will not go beyond 15,000. They have said that there is no such provision for under the Act, but they have said, as this has been there for some time, they are going to allow this law to continue for 6 more months. Within 6 months, if Parliament in its wisdom amends and brings about the required legislative changes, well and good. If not, this 1.16 is bad in law, and they would need to rework from 2014 onwards on this 1.16 that they have been claiming for pension. They said this increase from 12 months to 60 months average for pension, that is in order. So to that extent, they have said that's not bad in law. There are also a few contradictions in the judgment. We just try to point it out that the different places in the judgment. So in one part they say employees who have retired prior to 1/11/14 without exercising an option under para 11(3) would not get benefits extended in the judgment. Then they say those who have retired prior to 1/11/14 by exercising the option under para 11(3) shall be covered by the provisions as it stood prior to the amendment of 2014. And then they say members who do not exercise option under 11(3) would be entitled to exercise option under 11(4) within 4 months. And of course, there is also a very clear finding that they are upholding R.C. Gupta. So what is all this about? What are we looking at? As I already said, are you an employee whose salary has been above the ceiling limit? That's the first question. If your salary is above the ceiling limit, and if your employer has contributed on that basic wages, so let's assume 25,000, 30,000, on the entire 25,000, 30,000 contribution has been made, you can even today exercise an option saying, I want a higher pension. So from my employer's contribution, entire 8.33 of the entire contribution amount should go to pension, and accordingly your pensionable salary will become higher. So that option has been given to all employees who are existing in members, whether you're 2014, prior to 2014 you should have been a member, then you have entitled to this benefit. Similarly, those after 2014 also can exercise this option. There is no time frame, but you should have become a member of the pension scheme because your salary should have been less than 15,000 at some point of time. Become a member, and today you can exercise the option if it is crossed 15,000. But there is one area where this judgment may be lacking. As I already said, R.C. Gupta judgment said this option saying that I want a higher pension can be exercised at any point of time. There is no time frame. That is what R.C. Gupta said. Supreme Court now says R.C. Gupta is correct law. It endorses the view made in R.C. Gupta and it says that is correct law. But it also says that those who have retired prior to 1/11/14 cannot now exercise for a higher pension. Whereas R.C. Gupta said you can exercise at any point of time. Having said R.C. Gupta is right law and that law is not wrong, this judgment now in para 44(5) says they cannot exercise. So that seems to be some contradiction in that aspect. So this is the crux of the judgment. what it has held is, so if somebody's basic wages in August 2014 was 18,000 and he was contributing on the entire wages, even though the ceiling was rupees 6,500, can this person now give an option for higher pension for contribution? Yes, this person can give a higher contribution. So this is what the crux of this judgment